Hello, thank you for watching the Traffic Safety Resource Prosecutor's legal update on important traffic safety cases from 2020. Today we will be discussing a U.S. Supreme Court case, an Ohio Supreme Court case, and an Ohio Appellate Court case addressing several different traffic safety issues. So let's get started.
Have you ever had your traffic stop challenged in court because it was based on information you gathered by running the driver's license plate? The U.S. Supreme Court provided some helpful insight into this issue with its decision in Kansas v. Glover, which was decided on April 6, 2020. In Kansas v. Glover, a sheriff's deputy on routine patrol ran Glover's license plate even though no traffic violation attracted the deputy's attention to the defendant's truck. Upon running the plate, the deputy was alerted that the truck's registered owner's driver's license was revoked. The registered owner of the truck was Charles Glover. It is important to note that the deputy did not observe any traffic infractions and did not attempt to identify the driver prior to the stop. Assuming that the registered owner would be driving the truck, the deputy stopped the truck and found that Glover was indeed the driver. This case presented the following question: whether a police officer violates a driver's Fourth Amendment right by initiating an investigatory traffic stop when the reason for the stop is based on the officer running a vehicle's license plate and learning that the registered owner has a revoked driver's license. The U.S. Supreme Court held that when a police officer lacks information negating an inference that a person driving is the vehicle's owner, an investigatory traffic stop made after running the vehicle's license plate and learning that the registered owner's driver's license has been revoked is reasonable under the Fourth Amendment. Glover challenged the stop, claiming it was unconstitutional for an officer to pull over a vehicle based only on the fact that the registered owner had a revoked license. It is well-settled law that an officer may initiate a traffic stop when there is articulable and reasonable suspicion that the person stopped has committed, is committing, or is about to commit a crime. While challenging the stop in the state trial court, Glover claimed that the officer lacked this reasonable suspicion and attempted to suppress all evidence seized during the stop. The Kansas District Court initially granted Glover's motion to suppress, but the appellate court reversed, and the Kansas Supreme Court eventually reversed again, holding that the deputy did not have reasonable suspicion because his inference that Glover was behind the wheel amounted to only a hunch that Glover was engaging in criminal activity, and that mere hunches are insufficient to provide reasonable suspicion and justify a traffic stop. The U.S. Supreme Court, in an 8-1 decision, reversed the Kansas High Court. The court held that it is generally reasonable for an officer to conduct a traffic stop of a vehicle if the registered owner's license is revoked. The majority reiterated that an officer's mere hunch will not be enough to establish a reasonable suspicion, but noted that an officer is permitted to make common sense judgments and that that standard does not require officers to achieve scientific certainty. The court noted that the inference that the driver of a car is the registered owner does not require any specialized training. Rather, it is a reasonable inference made by an ordinary person on a daily basis. In this case, the deputy observed an individual operating a 1995 Chevrolet 1500 pickup truck, knew that the registered owner of the truck had a revoked license, and that the model of the truck appearing in the database matched the observed vehicle. From these facts, the deputy made a common sense inference that the owner of the vehicle, Glover, was likely its driver. The court, in its majority opinion, noted that these facts and common sense inference provided the deputy with more than reasonable suspicion to initiate the stop. The court noted that officers, like jurors, may rely on probabilities in the reasonable suspicion context. The court noted that the reasonable suspicion standard takes into account the totality of circumstances, and that it is possible for the presence of additional facts to dispel reasonable suspicion. For example, if the registered owner is a male in his 60s and the officer observes that a driver is a female in her 20s, then the totality of the circumstances would negate the reasonableness of this stop. However, in this case, the deputy possessed no information to rebut the reasonable inference that Glover was driving his own truck. The court concluded by reiterating its precedents that the ultimate touchstone of the Fourth Amendment is reasonableness, and that the officer in this case drew an entirely reasonable inference. Thus, the court held that the stop was reasonable because the officer did not have any information that would rebut that reasonable inference that the owner of the vehicle was driving.
Next, we are going to discuss an important Ohio Supreme Court case that was decided in June of 2020, Brook Park versus Rodajev. It's a positive decision for prosecutors and law enforcement because the court's holding relieves the prosecution of its burden of proving that speed measuring devices are scientifically reliable. The main purpose of the Ohio Supreme Court's analysis in this case was to address the admissibility of speed detection device technology, since it had not done so since 1958, and the technology has changed since then. The big takeaway of this case is that the court held that the results of a speed measuring device using either radar or laser technology are admissible in court without expert testimony establishing, or the court taking judicial notice of, the reliability of the scientific principles of that technology. To give you a little bit more background on the case, the defendant was charged with exceeding the posted speed limit by 15 miles per hour in May of 2017. The Brook Park police officer who cited the defendant had measured his speed using an LTI 2020 TrueSpeed S laser speed detection device. During the defendant's bench trial, the trial court admitted into evidence and considered the results of the laser speed measuring device without expert testimony establishing the reliability of the scientific principles underlying the device's technology. Also, the trial court did not specifically take judicial notice of the device's scientific reliability. The trial court convicted Rodajev of the charged offense. The 8th District Court of Appeals affirmed the conviction. The Ohio Supreme Court determined that there were conflicting decisions regarding the admissibility of the results in appellate courts around the state and accepted the case for review. The court had not addressed the reliability of scientific principles underlying radar speed measuring devices since 1958, before laser was even utilized. Further, it had never addressed the admissibility of results of laser speed measuring devices based on the reliability of the scientific principles underlying that technology. The court accepted the case to answer the following question: whether the results of any speed measuring device using either radar or laser technology are admissible in court without expert testimony establishing or the court taking judicial notice of the reliability of the scientific principles underlying that technology. The court answered the question in the affirmative. It first looked at radar speed devices. After a detailed analysis, the court held that the results of a radar speed measuring device may be admitted into evidence without expert testimony establishing the reliability of the scientific principles underlying the technology. The court then addressed laser speed devices and said that it is satisfied that the scientific principles underlying laser speed measuring devices are sufficiently reliable, and held that the results of laser speed measuring devices are admissible in Ohio without expert testimony establishing the reliability or the court taking judicial notice of the scientific principles underlying the technology. The court stated that its decision on this issue is in accordance with decisions from courts in several other states. It's also important to note that the court's decision still allows defendants to challenge the accuracy of speed measuring devices at trial. The fact finder still has to determine whether the evidence presented concerning the accuracy of the speed measuring device and the qualifications of the person who used it are sufficient to support a conviction based on the device's results. The court stated that other substantive challenges to the results of a laser speed measuring device, including challenges involving the angle at which the officer held the device in relation to the targeted vehicle, the device's accuracy validation algorithms, and the device's calibration and maintenance schedule, as well as the officer's qualifications to use the device. These all implicate the sufficiency and the weight of the evidence, not the admissibility of the results. Determinations involving sufficiency and weight of the evidence are to be made on a case-by-case basis. Basically, the court's decision allows prosecutors to use the speed device's results at trial without having to rely upon a prior decision that admitted scientific expert testimony or having to subpoena an expert witness, usually from the manufacturer, to get the results into evidence.
Next up, we are going to discuss a recent 1st District Court of Appeals decision, State v. Eads, which was decided on May 6, 2020. Eads was involved in a single-car crash in April of 2017, which left him unconscious. Paramedics transported him to University Hospital in Hamilton County for medical treatment. As part of this treatment, the hospital tested his blood and urine for drugs and alcohol. Law enforcement officers investigated the crash scene and cited Eads with OVI under the influence. Several months later, during the investigation, the officer sent a written request to the hospital's medical records department for Eads chemical test results pursuant to Revised Code 2317.02 and 2317.022 and bypassed a search warrant to obtain these medical records. These statutes provide law enforcement officers a mechanism to receive medical records pertaining to the chemical test results of an individual so long as an official criminal investigation has begun or a criminal action has commenced against that individual. Revised Code 2317.022 specifies that language that must be included in the written records request. And Revised Code 2317.02 B2A requires healthcare facilities to provide the alcohol and drug test results upon receiving a records request from law enforcement. It also states that these chemical test results are exempt from Ohio's physician-patient privilege in criminal actions. In this case, after receiving the records request form, hospital personnel gave the requesting officer a copy of Eads' blood and urine test results. Eads challenged the admission of these chemical test results by filing a motion to suppress, claiming that the officer obtained his medical records through a warrantless search and violated his privacy rights under the Fourth Amendment, which protects individuals against unreasonable searches and seizures. The trial court denied the defendant's motion to suppress because it determined that Eads lacked a reasonable expectation of privacy in his medical records containing the chemical test results, and Eads appealed his OVI conviction. In the First District Court's analysis, it noted that there is a conflict between appellate courts as to whether an individual's Fourth Amendment rights are violated when an officer without a warrant or patient consent uses Revised Code 2317.02 and 2317.022 to obtain chemical test results from a treating hospital. Several Ohio appellate districts have ruled that a defendant's Fourth Amendment rights are violated when the officer fails to obtain a warrant or has an exception, including the 3rd, 5th, and 6th districts. The 8th District in City of Cleveland versus Dames held that law enforcement officers may obtain chemical test results from a treating hospital without a search warrant when they follow the statutory procedures within Revised Code 2317.02 and 2317.022. In this case, the court concluded that Eads had a reasonable expectation of privacy in his hospital records containing the alcohol and drug test results. The court noted that the officer was able to see too far into Eads' private life without the protections provided by a warrant, a right guaranteed by the Fourth Amendment. Because of this, the court found that obtaining chemical test results from a treating hospital without a search warrant pursuant to Revised Code 2317.02 and Revised Code 2317.022 violates an individual's Fourth Amendment rights. The court held that the chemical test results the officer obtained from Eads' treating hospital through the statutory authority was the product of a search, and that the officer was required to obtain a search warrant for the medical records. Ultimately, the court held that the exclusionary rule did not require the suppression of the chemical test results due to the good faith exception, because it was objectively reasonable for the officer to rely on the statutes, Revised Code 2317.02 and 2317.022, to obtain the records without a warrant. However, this exception will likely not apply to future cases when there is an appellate district decision on point that holds that these statutes do not authorize a warrantless search of hospital records to obtain the chemical test results. Thus, we wanted to highlight this case to show that a majority of appellate districts in Ohio that have addressed this issue require a search warrant for medical records. The Ohio Supreme Court has not yet addressed this issue directly.
Thank you for watching this legal update. If you have any questions regarding these cases or would like to discuss further, please email us.